Ready? 3, 2, 1, start. According to Section 4 of the Juvenile Justice Care and Protection of Children Act 2000, a duly constituted Juvenile Justice Board shall have the powers conferred by the Code of Criminal Procedure 1973 on a metropolitan magistrate, or as the case may be, a judicial magistrate first class, to consider the case of the petitioner. Stop. More particularly, Section 12 (1) of the Act confers special powers to Juvenile Justice Board to grant bail to a juvenile who is an accused of a bailable or non-bailable offence. Stop. It is manifest that the above provision provides certain specific conditions for consideration for releasing a juvenile who is accused of a bailable or non-bailable offence, and the said special authorization begins with notwithstanding anything contained in the Code of Criminal Procedure 1973 or in any other law for the time being in force. Stop. According to subsection (1) of Section 12 of the Act, a juvenile shall be released on bail with or without surety, notwithstanding anything contained in the Code of Criminal Procedure 1973 or in any other law for the time being in force. Stop. The first part of the provision appears to be mandatory in nature for release of a juvenile on bail, but the second part also equally appears to be mandatory for refusing bail, as a juvenile shall not be so released if there appears reasonable ground for believing that release of juvenile is likely to bring him into association with any non-criminal or expose him to moral, physical or physiological danger, or that his release would defeat the ends of justice. Stop para. A juvenile justice board has been constituted under Section 6 of the Act to deal exclusively with all proceedings in respect of a juvenile in conflict with law. Stop. Section 6 of the Act reads as under Section 6. Stop. The powers conferred on the board by or under this Act may also be exercised by the High Court and the Court of Session when the proceeding comes before them in appeal, revision or otherwise. Stop. A conjoint reading of sections 6 and 12 of the Act would reveal that to deal with all the proceedings including bail etc. in respect of juvenile, a juvenile board is the appropriate authority, and it has been constituted exclusively for this purpose, and no court, either Sessions Court or High Court has jurisdiction to deal with the proceedings pertaining to a juvenile. Stop. Over.